Good morning. Welcome to the Infinity Workforce Solutions Fast Forward webinar series. We appreciate everybody taking some time out to join us this morning. My name's Steve Kessler, and I'll be the host for the program today. I have to tell you, we have probably one of the better topics that we've presented in quite a while, and I think it's very important. Today's industry, with all the nuclear verdicts that are so common out there today, I think it's important to talk about things like negligent hires and retention, things that can cause a lot of problems as these lawsuits come up. So we're very excited to welcome our guests and take in all the information that they've got to provide for us. I do want to let everybody know, as you've joined the webinar, everyone is muted, so we can't hear you. So if you have a question, there's a chat box there at the bottom, or there's a Q&A tab there that you can pose a question, and we'll try to answer those at the end of our presentation. And just to let everybody know, the webinar is being recorded. We always get questions about that, so we'll make a link available after this has all been processed. I do want to introduce Mark Rhea. He's my co-host. Some of you that have been on our webinars before know Mark. He's joined us for most of our programs. Mark is a transportation executive veteran, 35 plus years in this business. Mark's a certified director of safety. He has a CDL. He's a CMV inspector. And I believe, Mark, if I'm not mistaken, you've been involved in your career in more than 20 lawsuits. So I think you've got a little background in this business.
Yes, I've been the company representative in at least 2025, so I'm very familiar with that. And as we dive into this reality of risks that we take every day when we put our drivers out on the road, I'm hoping that I know that Lauryn and Eric will provide us this theory of defendability. What can we do to help our defense attorneys defend us in the event we get involved in a lawsuit, which we will. If we haven't, we will. So we're really looking forward to that. Don't give the plaintiff's attorney a bullet to shoot you with is I think, going to be the theme today.
Great. Thanks, Mark. So I don't want to delay here. I do want to introduce our presenters today. We have two attorneys from the Benesch law firm. I believe they are located in Cleveland, Ohio. So I'm going to introduce ladies first. Our first guest is Lauryn Robinson. Lauryn is an associate at the firm and has experience handling a variety of complex commercial litigations in state and federal court. Lauryn's practice covers general commercial litigation, consumer class actions, and transportation and logistics related claims. Lauryn has a great background, a couple other areas. While Lauryn was in law school, she served as a judicial extern to the Honorable Melody Stewart of the Supreme Court of Ohio, and has also served as vice chairman of the CSU Moot Court team, as well as an executive board member for the CSU chapter of the Black Law Students Association. So welcome this morning, Lauryn. The other guest joining us is actually a partner in the law firm, Eric Zalud. Eric is actually the co-chair of the firm's Transportation and Logistics Practice Group and vice chair of the Litigation Group. And I have to say, this is a powerful law firm, folks. Under Eric's leadership, the firm has been named for, how many years here? 2023, 2022, 2020, 2017, 2016, 2014, as U.S. News and World Report Best Law Firm. So we have some powerful folks here that are going to give us a lot of insight. I do also want to mention that over the past 18 years, Eric has taken 36 cases to trial, and his record in these cases is 33-3. So we have a couple of experts here, and I hope that you'll give your attention to some great information that's about to come. So Lauryn and Eric, I will turn it over to y'all.
Thanks, Steve. It's Eric Zalud. It's a great introduction when the moderator pronounces our firm name correctly and my last name correctly. You did both, so it's good to be here with everyone. Yeah, Benesch, we have about 400 lawyers in Cleveland, Columbus, Ohio, Wilmington, Delaware, New York City, Chicago, and San Francisco. But within that, there's 34 of us in our transportation practice group, 11 of whom used to be in the industry, either at brokers, motor carriers, or forwarders. And yeah, that ranking was the number one transportation law firm. But enough about us. I mean, Mark, you mentioned that a lot of people in the audience are concerned about dealing with risks on the road. This panel is about hopefully keeping that to risks on the road, because the plaintiffs bar, as a lot of the audience on this call knows, I'm sure, is trying to move those risks in casualty litigation from the road back to the yard, the terminal, the DC, the corporate headquarters. And this presentation in part deals with how we can keep the risks to the road and not in those other places. So let's set the stage. Perfect timing. I think a lot of you on this call have heard about nuclear verdicts. So this is just a bit of a preamble setting the stage. A lot of you have probably seen the ATRI report. It's a few years old now, but the definition of a nuclear verdict is $10 million or higher. I was just at an ATA conference last week in Minneapolis and heard a verdict expert speaking, and she said, that figure is a little light these days. So it's a tough world out there. And here's how it's evolved. And between 2006 and 2011, cases with verdicts exceeding 1 million increased by over 250%, and 1 million isn't chump change either. And that's a lot of policy limits, although that's pretty low these days for a policy limits limitation. And the average size of the verdict increased from 2.3 million to 22.2 million. So the mean verdict, I think I remember that from algebra, increased by 51.7%. The next page is kind of a graph showing that. So I didn't do the math on this, someone else did, but it's a 967% increase. And another phenomenon that has arisen from the nuclear verdict phenomenon is what's called nuclear settlements. I'm involved in a lot of these, either for the insurer or for the insured in the event that there is a policy limits risk. And a lot of cases in the last few years have settled for more than $10 million because of the fear that they could get hit for a lot more. So the new unfortunate term, everyone, is nuclear settlements. So what goes hand in hand with nuclear verdicts is the development of what's called the reptile theory by the plaintiff's bar, and I'll talk about the plaintiff's bar in a minute. And by that theory, what the plaintiffs hope to do is seek to vilify the motor carrier, the trucking company, seek to invoke fear of the company, its trucks, into the jury based on their experiences on the road themselves, so that to cast it as an enemy, an evil enemy of the community. And it's amazing, and I'll get to this because it relates to our topic. So many cases these days, they're barely about fault in terms of the accident. They're barely about proximate cause. They like to try to get to some of the stuff we're talking about, which are policies, procedures, and practices of the motor carrier. These are direct quotes from, I've heard some plaintiffs' lawyers speak on this, that we imported to some of our conferences. And they have tip sheets. So pay especially close attention to regulations that deal with FMCSA safety reporting, pre-employment screening, the use of electric onboard recorders, and changes to the new entry program for commercial carriers. Keep in mind that each carrier is evaluated by its own individual Department of Transportation number, and this number can change when a driver changes hands, when a carrier changes hands. In your pending cases, find out if the carrier's fleet was recently purchased or merged, etc. So a lot of companies out there, probably some on this call, are pretty complex enterprises, maybe a brokerage division or subsidiary, maybe different modes, truckload, LTL, flatbed. Be careful of any safety information on any of those entities' websites. Even the word safe or safety can be used against you in this litigation. The plaintiff's bar is so sophisticated, my last point on this slide, that they don't go to seminars anymore on how to find out who's at fault in an accident. They go to seminars on how to pierce the corporate veil to get at affiliate companies or parent companies. More of some of what's in their playbook. You hear some of this in opening statements. Trucking companies notoriously cut corners and do the absolute minimum required by federal and state law when they do background checks on new drivers and train new drivers. We'll be talking about some of that. The defense intends to focus on the 30 seconds before the crash. And when I handle a case, I look long before that. I look at how he was hired, how he was trained, how he was supervised. The FMCRs are only minimum standards. I disagree with that. And trucking companies should do much more. So one thing to note about all those quotes, they don't relate to the accident, right? They relate to the policies and practices of the motor carrier. We've covered a bit of this on this slide. This is the era we're in. The plaintiff's bar is very well organized. They share litigation materials much more readily than the defense bar. If you have a corporate rep who's had his or her deposition taken, and that's not marked confidential, that starts circulating amongst the plaintiff's bar. Experts' reports are shared, tactics are shared, and I say they're well funded, right? Because there's a lot of plaintiffs' law firms that have won large verdicts now, and so they don't worry about being outspent by the defendants. They're funded, and that doesn't become a decision point. Litigation funding is in our world now. That could be a whole nother PowerPoint, but it's a problem for us that they're well funded. And as I say here, in lots of cases, proximate cause and fault for the actual accident becomes a secondary issue in the litigation, and the tail starts wagging the dog. And that's what we're going to be talking about here. That includes spoliation of evidence claims, but also digging in broadly and deeply into hiring, retention, and training practices. Now, this could be another whole topic also, but there's states more and more that are regulating some of these issues and making it harder for plaintiffs to get nuclear verdicts. Texas has excellent statutes. There's still some big verdicts there, but I think the statute helps. Florida just passed one last year. I wrote a whole article about it, but it's too much to go into here. But there's a little bit of hope from state legislatures. I'm ready. So, as your outside counsel, how do you combat this? We always represented our motor carrier clients, brokerage clients zealously, but in this era of reptile theory tactics and nuclear verdict occurrences, we fight at every single opportunity because we know that every single piece of paper, every single piece of electronic data or email, every single word of deposition testimony, once it's out there, it can be used against our clients in malevolent and unpredictable ways. So Once something is out, you can't unring that bell. So we fight hard at every opportunity, much harder than we did before. What can you do as motor carriers, as clients, as litigants, having good internal programs, which we'll talk about. First of all, it prevents the tail from wagging the dog, but of course, they prevent the initial claim themselves. So it's important to have updated, comprehensive training and safety protocols. I'm sure most on this call do. And most importantly, if you have them, you got to comply with them. And the worst case is we have this excellent protocol and program. Well, did you use it here? Well, no, we didn't. That could be punitive damage territory. And also, as importantly, document that compliance. Document that you conducted that training program. And my last parenthetical is as important. Document who showed up for it. This driver was there. We had this program. We conducted these sessions, and he or she was actually there. Here's proof. So that really helps. Just some more mind-boggling verdicts. These are a little old now, by the way, a few years old, but 89 million in Texas. Texas is still a bad state. 165 million in New Mexico. That's another bad state. Another one in Texas, 280 million in Georgia. So there are certain states that are the worst. Some of them are up here, unfortunately. But all of these particular verdicts have one thing in common, and that's what we're going to be talking about here, and that is some of the issues in the litigation had absolutely nothing to do with who was at fault for the accident. They dealt with negligent hiring, training, supervision, retention, or trust. In other words, direct claims against the motor carrier. They are problematic, and I touched on this, but what they do is they can let the plaintiff's lawyers dig into everything, right? All your policies, the maintenance history, not of just the vehicle involved, but all of them. A lot of broad-based discovery that has nothing to do with who was at fault. And I tell you, even the best, and a lot of you on this call, I'm sure, are the best at these practices and documentation. There's always something they can latch onto. So to get rid of these direct action claims is so beneficial to the motor carrier, because that's what the plaintiff's lawyers use to fuel passion and anger and emotion in the jury, not really the facts about the accident. So one thing that can be done to diffuse this, and it's done a lot, but not all the time, is admit that the driver was acting in the course of his or her employment. And in many, slightly more than half, I'd say the majority, if you admit that, and a lot of times that's a pretty easy admission. Sometimes the driver, is almost in criminal territory, and so you can't. But that tears down the claims that we're going to be talking about, negligent hiring, supervision, and training. So that's an early stage litigation strategic decision. And I'm sure your outside counsel will be aware of the pros and cons of it. So as I said, those claims go away in majority jurisdictions. Then, they're limited, right? The plaintiffs in discovery. They can't dig into overall policies and practices as to all your drivers and all their records, because case becomes focused then on whether that one driver during this one accident was acting negligently. So if the driver is found not liable for that fault, then the motor carrier is not liable. that's pretty great. And these states consider these claims, direct negligence claims, as an alternative for imposing liability on employer motor carrier for an injury caused by its driver. Once that's admitted, this discovery becomes unnecessary. There's exceptions, though. Sometimes the plaintiff's claims the motor carrier was so egregious that we're in punitive damage territory, and this happens a lot. And it happens in nuclear verdict situations a lot. That's one of the elements that ramps it up. And so even in majority jurisdictions, these claims can survive in certain situations. Admitting agency won't result in dismissal. I say it's reserved for the most extraordinary cases, but unfortunately, there's a lot of cases where punitive damages are alleged and they at least make it through to trial. Maybe they're thrown out before, but it still gives the plaintiffs grounds for broader discovery.
Eric, when you mentioned drivers, I'm assuming that's not limited to company drivers. That also would include independent owner operators.
Right. Yeah. I mean, I consider, good question. And the courts, it's not just me. I mean, if a driver is an employee, clearly, this theory works with that. And if a driver is operating under your authority, if your placard at its door, then yes, the same thesis applies to ICs, owner operators. Good question. Minority view, this is probably like 20 states, are just the opposite, right? They say it doesn't matter. If you admit liability, you can still chase after the motor carrier for these other direct actions that we're talking about here. The motor carrier's negligence in a different manner. And that's perfect, as I say, for plaintiff's reptile theory strategy. If these claims are allowed to survive, then that's when the focus shifts from fault of the accident, who's at fault for the accident, to, and here's classic reptile theory, right? The plaintiff, they say, the motor carrier, the big bad motor carrier created unnecessary danger for the plaintiff and the community as a whole by violating safety rules. That's one of their mantras in these cases. That's how they expand, that's how they vilify, and that leads to nuclear verdicts. These issues come up a lot in the cases, and we got some pretty recent cases here, and Lauryn's going to touch on a few of them, then I'll close us out, but we still have good chunks of time, Lauryn, so go ahead.
Sure. So the first case that we'd like to discuss is actually out of Kentucky, Short versus Marvin Keller Trucking. This is a motor vehicle accident that resulted in a fatality, unfortunately. While the cause of the accident was disputed by the parties, it was agreed that the driver lost control of the tractor trailer and crossed an interstate median. After the accident, the estate asserted, amongst other things, these claims of direct negligence. So retention claims, supervision, and training claims against the motor carrier. More specifically, the estate claimed that the motor carrier should have terminated the driver because of his driving record and his health history. The driver's driving history included some citations related to hard braking and distracted driving. The motor carrier did require that the driver attend some distracted driving courses just to make sure that the incident or the citation was remedied. His medical history also suggested that he, in the past, had a condition where he would get headaches and may at some times lose consciousness. Plaintiffs claimed that the motor carrier was subject to these direct liability claims because they knew about this medical condition, and they should have known that it may have impacted his ability to drive during the accident. When reviewing the plaintiff's allegations, the court was careful to make to note that these were all direct negligence claims against the motor carrier, and the key inquiry was whether or not the incidents could have been avoidable and whether or not it was foreseeable. The court also noted that elements of torts of negligence, hiring, and retention are distinguishable elements from negligent retention, supervision, and hiring claims. Importantly, all of these torts require that the employer's failure to exercise ordinary care in managing the employee create a foreseeable risk of harm. So again, as Eric mentioned, this all goes back to foreseeability. In this case, the Eastern District of Kentucky ruled that summary judgment should be granted with regard to those supervision and training claims against the motor carrier. The key reason why the court ruled in favor of the motor carrier was that there was no dispute that the employer actually complied with federal motor carrier safety regulations. So they performed the necessary background check. They had done a deep dive into the driver's record, and there was no indication or suggestion that the driver was unable to perform his job or was unfit to perform his job. So in this case, the court primarily relied on the idea of whether the incident was foreseeable and whether or not the employer, the motor carrier, had any indication that the driver was unfit to perform. The next case here is actually out of Texas. It's Johnson versus Cox. This dispute arose out of a motor vehicle accident, and the plaintiffs claimed allegations of negligent qualifying, hiring, training, retaining, and supervising. In this case, the driver was employed by two motor carriers. It was important in this case that the driver did not have any prior incidents on his driving record, and that is actually one of the things that saved the motor carriers from liability in this case. The motor carriers, prior to hiring the driver, had done a very clear, well-documented investigation into the driver's commercial driving record. They made sure that he had a valid commercial driver's license. They confirmed that he was adequately insured and maintained that insurance throughout the course of his employment. They also performed safety tests with the driver and made sure that they were aware of his personal driving record. It was also significant in this case that the motor carriers made note that the driver performed poorly on a previous safety exam during his hiring, the course of his hiring, and they were sure to provide additional training related to safety, and that training was well documented. The court ultimately granted summary judgment on the negligent training and supervision claims because there was no indication that the driver lacked fitness or had dangerous tendencies. They also granted summary judgment on the negligent retention claims because there was no evidence that the driver was an incompetent commercial driver. There was some evidence suggesting that there were citations related to speeding, not using a parking brake, etc., on the driver's personal record, but the court did not consider that when issuing the ruling in this case. They also did not consider any of the driver's personal incidents on his personal driving record. In fact, the court primarily relied on whether or not the motor carriers complied with the federal standards. That case in general was just a reminder to make sure that you are developing those policies where training is well documented. It's always helpful to not only make note of the date and topic of a particular training, but also consider having your drivers authenticate or attest to the fact that they attended that training. Also, it's important to note, in some cases, whether or not the training was offered in person and what materials were provided during that training. The next case here is out of Alabama. So this lawsuit is another incident involving a tractor trailer. The plaintiffs were injured and alleged claims of negligent and wanton hiring, training and retention, and supervision against the driver. This case is a little unique because it shows the realities of what you can face if you do not maintain accurate policies related to training, supervision, etc., and how that can impact the motor carrier. Eventually, in this case, the motor carrier did seek partial motion for summary judgment for these negligent claims. The court noted that implicit in torts of negligent hiring, retention, training, and supervision is the concept that, as a consequence of the employee's incompetence, the employee committed some sort of act, wrongdoing, or tort that caused the plaintiff's injuries. However, the court was careful to mention that the question of incompetence only applies to negligent supervision, training, and retention claims, not those related to negligent hiring. The court also readily acknowledged that pre-hire citations, even minor vehicle accidents on personal driving records, are not relevant to determining liability in these cases. The court decided to ultimately grant summary judgment as a result related to negligent hiring. However, the court actually denied summary judgment related to the negligent supervision, training, and retention claims because there were material facts or material disputes, rather, as to whether the motor carrier overlooked the driving records from the driver, which were heavily edited, redacted, and the court believed that this was a suggestion that the driver may have been in violation of federal safety regulations. Further, there was an issue or dispute, rather, regarding whether or not the motor carrier gave the driver training on how to amend or properly document his driving logs, despite having knowledge of his failure to adequately complete them. So this is important to note because before Eric mentioned that there is a majority and minority rule. In most circumstances, the courts will find that as long as you comply with federal standards, you are generally able to avoid liability. However, this is a suggestion that the lower court here did not agree with that, and it was up to the appellate court to rule on this. The final case that we're going to discuss is a state of Fields versus Fields.
You're going to discuss. I got one.
Oh, you're right. Thank you. So this case is a case out of Iowa. This just goes back to the importance of accurately documenting whether or not you have employed a driver or whether or not they are associated with a independent contractor. In this case, Landis engaged Shaw Trucking as an independent contractor. Shaw Trucking then hired driver Troy as the driver to actually haul the product in this case. While transporting the load, Troy crashed into a farm tractor, and actually the accident resulted in a fatality. The estate filed a lawsuit against Landis and the motor carrier for claims of vicarious liability and direct liability related to the driver's negligence. Landis eventually moved for summary judgment on the negligent hiring claim, contending that it had no duty to evaluate the qualifications of its independent contractor. While that is generally the traditional rule, the district court denied that motion, finding that since there was undisputed facts suggesting that all parties knew that the driver did have a history of drug use, that Landis had a duty to investigate the qualifications of the driver. However, on interlocutory appeal, the court acknowledged that it wasn't really Landis's duty to perform this investigation, and it actually was the job of the independent contractor who hired the driver itself. Again, this just shows that while there are majority and minority rules in this area, courts don't necessarily rule the way that you expect them to. It's encouraged, rather, to investigate these things, even if you are not the entity that actually hired the driver. That could be a quick fact check or making sure that you have documentation in your possession suggesting that the standard regulations are met. So just a quick verification that the driver has a valid commercial driver's license, is adequately insured, and having documentation to reflect that can really help you defend against these types of litigation. Eric, you can take the next one.
So thanks, Lauren. I mean, some of the things we noticed from the cases Lauren just discussed are that the defendants can win. You saw several of the cases that Lauren discussed where the motor carrier defendants were able to get the claims thrown out, dismissed at the summary judgment phase. So that's good to know. I mean, obviously, that eliminates all risk of a nuclear verdict. So at least that's there. And, you also notice a lot of them from Texas. I guess it's a big state, but it's also still, even in the light of that most excellent statute, a little bit of a scary hotbed for these types of cases. I think I have about 9 of them in Texas right now. So the legislature there is working, but maybe it hasn't coursed through the litigation cycle yet, that statute. There are negligent maintenance claims also. This one happens to be in Texas. Here, there was an accident in Austin. The driver was doing an OLOW load on a prearranged route that they permitted in advance. He took a wrong turn, and this seems to happen a lot, colliding with an overpass. The load left the vehicle in some fashion and hit a nearby car and caused some injuries. So the plaintiffs filed a lawsuit against the driver himself, his employer, even better, which was an LLC, so a motor carrier, trucking company, and also an individual, 50% owner of the company. There was some evidence here of out-of-service violations on the truck related to faulty brakes, and the trial court found all 3 of the defendants, the driver, the trucking company, and one of the individual owners of the motor carrier, negligent and grossly negligent. So the defendants all appealed, and sometimes these terrible verdicts could be either reversed on appeal. There was just in Cook County, Chicago, there was just a $19 million nuclear verdict a few months ago, reversed, was against a broker by an Illinois State Court of Appeals. So sometimes they can be reversed in their entirety. Other times the amount of damages can be awarded, can be lessened either in post-trial motions with the trial court or on appeal. And good things happen in this case for all of the defendants. The Court of Appeals reversed all of it in a very helpful opinion for those on this call. First of all, the company's owner, those claims were reversed because he can't be personally liable, right? That's the whole point of the corporate entity. So an individual, it's typically, this is probably good news for someone on the call, very hard for a plaintiff's counsel to get at individual owners, shareholders, officers, directors of the motor carrier in these cases. So a good opinion in that sense. And then the trucking company, where they were also reversed because the court found that they adequately trained the driver and he was not incompetent, pardon the double negative, to drive, to do the work. And when it dug into the negligent maintenance claim against the motor carrier, it noted that, of course, motor carriers are required to maintain their vehicles in safe, proper operating conditions. The FMCSRs require that drivers to, make a pre-trip inspection. But this was an excellent holding because what the court recognized, and this is what I've been talking about in these cases, that even if there was a negligent maintenance claim, you have to establish that somehow that negligent maintenance caused the accident. And the court dug in granularly to the physics of the accident, braking violations to be a cause of the incident. For them to be, there had to be they have to show that a timely application of the brakes would have avoided the collision. that requires expert testimony, and I'm surprised they did not have expert testimony of the plaintiffs. That's pretty obvious. And so because of that, they failed to establish causation of the accident for any of the negligent maintenance, and the case was thrown out. Of course, that probably took about 3 years and hundreds of thousands of dollars, but it was thrown out. So there, there's good news out there. And we put a lot of cases in this presentation that are good news. And a few tips in terms of immediately after the accident, how to handle the driver, try to get to him or her as fast as you can. And by that, I mean a dispatcher reaching out, or a compliance director, risk manager, having conversations. If you can get someone physically out to the accident, to talk to that driver, to be with him, that's very helpful for his or her peace of mind, but also for litigation down the road. That driver should not be conversing with anyone at the scene other than public authorities or on the scene. Everyone knows this. Make sure drug and alcohol test the driver. You got to remember that a lot of these situations are very traumatic for the drivers. And so, it's important to have concern, not just for your liability, but for the driver's physical and mental well-being. And then when the dust settles, you got to make the determination as to what do we do with this driver. I mean, a lot of companies have policies where if it's a fatality, the driver's automatically terminated, and they stick to that policy. I've had some clients who, or if it's a serious non-fatal accident, automatic termination. If you have that policy, you got to stick to it. I had a couple clients in the last few years who, against my advice, said, yeah, but he's a nice guy. He's been with us for a long time. He's close to retirement. We don't want to let him go. I think it's a bad decision. A middle ground is suspension. And if you're going to keep him or her around, it kind of it's a sliding scale, depending on the severity of the accident and his or her driving history. Another thing to evaluate is there possible criminal liability for the driver, including misdemeanors? And, we always advise our clients, if there's any risk of that, to, yes, obtain separate criminal counsel and pay for that criminal counsel. I mean, we usually want the driver on the same team, right, in litigation. We would like to do our best not to alienate the driver, and, having qualified criminal case counsel can also result in possibly, an acquittal on whatever charge it may be. That's happened to me a couple times, and it doesn't make the civil case go away, but it really prevents, inflammatory introduction of the criminal conviction by the plaintiff's counsel. A few other details of that. I'm gonna stop at like 11:50 and see if there's any questions. And I don't want to hear myself talk for a whole hour anyway, Lauryn. But first of all, let's get down to the nuts and bolts. Make sure they're safe, right? Make sure immediate post-accident they're out of danger, out of risks. That can include getting the heck out of the truck, standing clear of the accident scene. What the driver should do, and this should be part of training, is immediately notify the dispatcher, risk manager, whoever at the carrier, so that person can set in motion other things that you should be doing, right? Contacting outside counsel, notice the insurers, contacting accident reconstruction experts. Let me digress a minute here. I know Mark mentioned there was a PowerPoint presentation on questions about the juxtaposition between insurance counsel and retained outside counsel for the motor carrier. in these particular situations, and we do work for motor carrier insurers also, but I've had a lot of situations where, the company's outside counsel can get this stuff done a lot faster than you send notice to your insurer and they get things going. It can vary, but I think it's good to notify the insurer, make sure they get it rolling, but also notify your own outside counsel to make sure she gets things rolling. And then, we can fade away as insurance counsel gets involved, the insurer gets people out there. But sometimes, and I've experienced it, we can get these actions taken faster. Back to the PowerPoint. Once the public authorities get on the scene, the driver should just stand back, let them take the lead in handling the scene and rendering any aid to any injured parties. Now, in some states, there's Good Samaritan statutes. So, first of all, the driver shouldn't drive away. I have a case where we're still in there because of that. And there's obligations to take some actions to render aid if there's no one else to do that. So, but once EMS gets there, lay back and we'll let them do what they're good at. He or she shouldn't really contact anyone other than the dispatcher and, depending on the driver's condition, family members as necessary, careful of contacting anyone else. That's all discoverable. Yeah, and should always speak with law enforcement. And I've had questions. That's why this is in here. What should we tell him to say, Eric? Well, to other parties, even injured parties, only very innocuous common courtesies like, how are you doing? Don't get into deep discussions with anyone else on the scene other than law enforcement. Never admit to anyone their fault. Maybe sometimes that's hard to do. It's like a human reaction. But, like for instance, I'm sorry you are injured instead of I'm sorry. And that's because, some drivers may think they're at fault, but when you factor in the circumstances of the accident, the legal obligations, the other causes, lots of other legal factors come into play. So this one's probably hard to do, but it should be part of training if it can be. And then I've had clients say, well, what should he say when they're asking questions? The police on the scene. You got to respond, right? You can't not respond, but try to respond only to it's almost like a deposition witness. Try to respond only to their inquiries. Don't unnecessarily elaborate. Strive not to admit fault. Just summarize the facts. These are little morsels that who knows if they will even be remembered in the heat of the accident, but it's better to say our vehicles collided than I hit her, for example, if that can be done. And then make sure the dispatcher or whoever from the motor carrier, make sure we can get that driver out of there, away from the scene, as soon as he or she is allowed to leave the scene. Now, sometimes they'll be transported by EMS, and if so, someone should join them there, that the driver as soon as possible. So yeah, this is, you got to keep your heads up. You got to be thinking about these things in advance. Struthian, by the way, means ostrich-like. So there's an ostrich burying his head in the sand. Don't do that. Let's see what we have next on the slides, Lauren. I'll break now to see if there's any questions. I have some great slides about companies pushing back and having practices in place to prevent nuclear verdicts and reptile theory offensives right from the start. But maybe that could be for another PowerPoint. But I think, Mark, Kevin, we're gonna wrap because I don't want to take everyone's full hour. And if there's any questions, we can respond to the extent we can here. Otherwise, we can adjourn. Thanks, everyone.
Thank you very much, Eric. There is one question that came in here just a few minutes ago. Kirk asks, our company uses interchange agreements with other companies using our trailers to haul our loads. I'm new to the DOT position. Are these an industry standard? I guess, does it get more complex when you have arrangements like that?
It does. And by the way, whoever asked that, we do lots of interchange agreements. I don't, I'm a litigator, but we have 2 lawyers I can think of right now who work on those every day. And the answer, though, is it doesn't make your operations any more complex. There's ways to make those agreements, have your operations function smoothly. There's ways within those agreements to protect yourself a little bit more from liability. A couple other points. However, this is America, right? This is the land of the reptile theory, and I predict that the other entities would be dragged in casualty litigation. I just had one case down in Georgia where they brought in every single affiliate, every single parent company, unrelated leasing companies, the trailer owner. So they can be very broad. Now, specific to trailers, long answer, but it spurs a lot of responses, Steve. There's a specific amendment called, a specific federal law called the Graves Amendment, and it really protects those who lease trailers, the lessors of the trailers and the lessees. There's ways to get them out of any liability based on that statute. Depends on the circumstances of that particular agreement, but we've saved a lot of entities from going very far in litigation based on that specific amendment that's geared specifically toward trailers. So
What'd you call that amendment? Graves?
yeah, Graves, Graves, is named after I forget his first name, former governor of Kansas who was an ATA chairman.
Okay.
And it's more than an amendment; it's an actual federal law, but that's its common name.
Okay. One question that popped up in my head, you mentioned that I don't know whether it was you, Eric, or Lauryn, that said something about a driver's personal driver record not being included as part of the lawsuit. Is that something that ever is brought into play and sticks in a court case? A personal record?
Yeah, rarely. I don't want to say never because there's a lot of lawsuits out there and a lot of judges, right? But the sweep is what can get to be a wide one in these cases, but typically it's really only the driver's commercial record.
Correct.
About that, and usually most of the problems are in the commercial record. But yeah, I rarely have seen the driver's non-commercial driving record dragged into a case.
Okay, great. Obviously,
Still shouldn't run a red light in his Subaru, though, Steve.
That's right. One thing I'm hearing quite a bit through the entire presentation, obviously, companies have policies about hiring and retention and how they deal with all these things. And obviously, it's important if you have a policy to follow it, because the plaintiff lawyer will use it against you if you have a policy and nobody's been trained on it, you don't know it, and you don't follow it. Is it recommended that they routinely look at their policies and make sure that they've got them worded correctly? Are there things they can do in how they word policies to help themselves?
Most definitely. I was just at an ATA litigation seminar, and there's a whole panel on, the CDL manual and what you say in your handbooks. It can be used against you, just like websites can. Right. So you want to update them to make sure they're current in terms of new regs, new industry practices, but also, the principal function of them, of course, is to train the drivers so that you
Right.
don't have an accident, right? But they can be litigation fodder. So a lot of times there's superfluous verbiage. It could be incendiary that's in there that should be reviewed every so often. The other thing I'll say, you reminded me of another point, and I just raised this at that same seminar I was at on a different panel, but also record retention, right? So
Right.
it's important to have a records retention policy, but remember, everyone, the flip of the coin. Records retention also means when that time period elapses, you can destroy those documents, and that's not a bad word. So
Right.
I've had a lot of cases where companies say, well, we just kept them around. You don't have to. And so there can be documents you never know it's going to damage you that you don't need to be retaining. So have that policy, comply with it on both sides of the coin, retention and destruction/deletion.
Very good. Very good. One thing I do want to say to the audience out there, obviously, our company, Affinity Workforce Solutions, our whole business is around training drivers and making sure that you've documented that the training has been done. So it's obviously our platform automatically date and timestamps records all the training records. So if anybody out there that's not currently a customer of ours has an interest in hearing how we might be able to help you do proper training and make sure you have proper documentation, if you wanted to reach out to us, we'll tell you what we do and see if there's an opportunity there for us to help you be more defendable and make sure you have proper documented records. So having said that, one other question that popped in there.
Hey, Steve, can I tack on to that?
Yes, absolutely.
So I would say right on that topic, there's just 4 points, and I mentioned them all in my first slides. Number one, have a policy. Number two, comply with the policy. Number three, document your compliance. And number four, document it as to each individual. So
Yes,
that's one of the most important things from this presentation.
very good, very good. Mark, do you have any questions that popped into your head?
Real quick, I heard the word foreseeable risk used a number of times. Foreseeable risk or predictable risk. And one of the challenges our carriers have these days is the massive amount of data that comes in on drivers. Hard brakes, logbook violations. It's just almost unmanageable. Is it a good practice, or would you even make a comment on how to manage all of that data that comes in so that a plaintiff's attorney can't use it against you to make a case that you did have a predictable risk out there?
Yeah, it's a double-edged sword, right, Mark? I mean, all that data is important to the motor carrier from an operational standpoint. It's important to the motor carrier from a safety standpoint. So it probably helps prevent accidents. So right out of the box, that's good. But yeah, it in most litigation, it could be available to the plaintiff's counsel. So ways to do it are some of the things I just mentioned. I mean, the motor carrier can have policies where, after consult with counsel, okay, when we're done with this data, we're gonna delete it, and the outside counsel can fight like hell to make sure it never sees the light of day, right? And in terms of preventability, that's a buzzword, right? In the DOT parlance, there is just a nice, I think it's either a statute or a reg that says preventability determinations can't be used against the motor carrier in civil litigation. So I'm distilling that and simplifying it, but it's a great reg for carriers. It was later in my presentation. So that's helpful because it is helpful for a motor carrier to dig back and understand what went wrong, but they shouldn't be able to use that against you because you're trying to improve safety going forward.
Well, Eric, Lauren, we've come to an hour here, and we try to generally keep things to an hour because folks got other things to do, as I assure you and Lauren do. I do want to thank you all. This was great information. Very happy that you joined us this morning. I see a lot of our folks stayed on for the whole program, so they were hearing a lot of great things out there. So thank you, Lauren. Thank you, Eric. We appreciate it, and perhaps we'll have you join us again for a webinar in the future, but thank you all both very much.
You're welcome. We love this stuff, guys, so we love talking about it, and I had some more slides on a great topic. So
We'll see, we got another whole program then.
if you call, I'll answer the phone.
Very good. Thank you, sir. Appreciate it. Thank you both. Goodbye, everybody. We hope to see you on the next program.